Thank you. In a minute, we'll ask Judge Bernstein to call the meeting to order, and then she can go through the particulars. And I'd remind everyone that this hearing is limited to testimony from individuals incarcerated with the Pennsylvania Department of Corrections. And I believe we have 4 facilities connected. With that, I'll turn it to Judge Bernstein.
All right. Good morning, everybody. I apologize. I'm stepping in straight from another meeting, so I'm still awaiting the list of individuals who are going to be testifying. But I am the chair of the commission, and I welcome all of you. We've been doing more outreach and getting input for the various initiatives that we're implementing or being tasked with implementing. I've read the submitted written testimony, and we have found that seeking the information from incarcerated individuals as well has been very impactful in terms of decision making on the commission's side of things. What we're going to do is I'm going to keep peeking at my email to see if I can get the list of participants who are going to be testifying, and then we'll turn it over. But I think what I'll start is I'll have the executive director give just a brief background of where we are at this point with regard to the recommendations, and then I'll open it up for the testimony. So I'll turn it back over to the executive director briefly.
Great, thank you, Judge. And in addition to Judge Bernstein, who is commission member and chair, we are joined by Professor John Rago, a professor at Duquesne University School of Law. Sorry, Professor. And I believe we may be. Could people please mute if you're not speaking? Please mute. Thank you. So we hope to be joined by at least 2 other commission members, District Attorney Sunday from York County and Representative Bonner from, I believe, Mercer County. So they may be joining us a bit later. As background, the commission approved.
Can you ask Tanya to look here?
Excuse me, could you please mute? Thank you.
I'll mute them all from this side too, and then
thank you.
We can just unmute as we go along. Sorry about that.
Great, thank you. So the commission approved 3 proposals during a December 8th, 2022 meeting and published those 3 proposals in the Pennsylvania Bulletin on January 7th of 2023. This is the 4th of 6 public hearings being held on these 3 proposals. The first was held in Philadelphia on February 8th, the second in Easton on February 17th, the third in Pittsburgh on February 22nd. We have this one today. We have one later this week, March 2nd in Erie, and the final one, a hybrid hearing, will be held in Harrisburg on March 10th, beginning at 9 o'clock. So that hearing will be held in person, that people may attend and testify in person, or may participate by Zoom. The 3 proposals before the commission address sentencing guidelines, resentencing guidelines, and parole recommitment ranges. The sentencing guidelines have been underway, the redevelopment of the sentencing guidelines, since 2014. A working draft of the sentencing guideline proposals was published in January of 2022, and the commission held 6 public hearings then. And so since then, the commission has been working on finalizing what is now the proposed 8th edition sentencing guidelines, which is the subject of this hearing. The intent of the changes to the guidelines are to provide more targeted sentence recommendations regarding the disposition or sentence and the duration of the sentence, to reduce the overall impact of the prior record score, and to streamline and automate the use of the sentencing guidelines. For the resentencing guidelines, the proposal includes some minor changes to align the resentencing guidelines with the underlying sentencing guidelines. So for every set of sentencing guidelines, there will be a resentencing guidelines to be considered when someone is placed on probation and is revoked on probation. The resentencing guidelines are recommendations regarding the resentencing following revocation of probation. And the third, the state parole recommitment ranges. These are the initial parole recommitment ranges. This is the third proposal we've had out for public hearings. Earlier this year, the commission adopted and implemented, last year the commission adopted, earlier this year the commission implemented the initial state parole guidelines to be used by the parole board. These recommitment ranges are to be considered by the parole board following a revocation of state parole where a person is being recommitted to state custody. And so these recommitment ranges, if adopted, would take effect January 1st of next year and apply to any re-paroles at that time. And they make recommendations regarding the placement and the duration of any kind of recommitment following a revocation of parole. The commission is preparing an impact analysis on the sentencing guideline revisions, looking at the current resources used and the resources anticipated under the proposed guidelines. We expect those to be published later this week and available for discussion during the final public hearing on March 10th. And with that, let me just finalize the process moving forward. At the conclusion of all public hearings, the commission will hold a work session where they will review all testimony received regarding the three proposals. At any time thereafter, the commission may either amend and republish and hold more public hearings, or may adopt, modify and adopt the proposals and submit the proposals to the General Assembly for review. The General Assembly has a 90-day review of any matters adopted by the commission. And if at the conclusion of the 90-day review, the guidelines are not rejected, then they take effect. All three of these proposals have an effective date of January 1st of 2024. And that's one of the factors that the commission could modify if they chose to do so during the adoption process. And with that, I'll turn it back to Judge Bernstein in hopes that she has the list of those testifying. We have 4 facilities online: SCI Benner, SCI Cole Township, SCI Fayette, and SCI Muncie. Judge Bernstein.
All right, thank you. I do have the list. This appears to be alphabetical in terms of the SCI. We'll start with SCI Benner. And I think my hardest name pronunciation is first, so I'm going to hope I get this right. This is Don McGuigan from SCI Benner. Are you present? And please feel free to correct pronunciation if I was incorrect. So SCI Benner, I see you're currently muted, so you're going to need to unmute. Thank you. And then you may begin.
Okay. I'm just going to speak to that, which I know is relative to my situation as far as the sentencing guidelines. I realize they've been overruled in court. I was sentenced under 7508, 187508, mandatory minimums and enhancements. And since that time, my case is from 2004, and I was sentenced in 2008. I don't know what the commission is planning on doing. I've been reading for years where they were looking to reinstate some type of minimum standards for sentences, but I don't know what the outcome of that was. The only thing I wanted to speak to was when I was sentenced, I was a first-time offender, and what they did was they took 8 separate complaints. I was convicted at the same trial on 8 separate complaints, and they gave me the initial sentence as a first-time offender with my first complaint. And then they used that first complaint to enhance the sentencing guideline for each subsequent complaint. And I was just going to speak to that and suggest that if that's on the table for that type of thing, that the commission not do that for first-time offenders, that when you're sentenced to on the same day by the same judge with one set of cases, that you not use the first case as the first one and then enhancements, use the first case as a prior. I don't know if I'm being clear on that. But that's what I want to address as far as the sentencing guidelines. Can they hear me?
Thank you.
Did you follow that, Your Honor?
Sorry, I was trying to unmute. I did follow that. I didn't, if the executive director wants to speak at all to that issue at this point, or if you want to take it under consideration.
Sure, I'll just make a brief comment. So first, thank you very much for your testimony. You are correct that there are a number of mandatory minimum sentencing provisions, and those are enacted by the General Assembly, but there's a number of those that had been in place, and many of those have been invalidated, so they are no longer in effect in Pennsylvania. But there are provisions under the Drug Act regarding the doubling of, in that case, the mandatory minimum, but also the doubling of the maximum sentence possible based on what we call predicate offenses. And so you are correct that for multiple drug convictions, drug trafficking convictions, a second or subsequent conviction would increase the maximum penalty. It would double the maximum penalty. And it can be, as you said, during one case before the court, or one hearing before the court. But the same did apply in terms of the mandatories. But again, those have been invalidated. So just to sort of clarify, or to agree with your point that has been the case, that is different than the sentencing guidelines. The sentencing guidelines, if someone is in court as a first-time offender and has multiple offenses, there would be no prior record score if this was a first-time offender. If someone was in court subsequently, then we look at any prior offenses under this proposal and identify the most serious and the number of similar situated offenses. So thank you, Judge.
Whether it was relevant or not. So thank you.
No, appreciate your comments very much. Thank you. Next, we're going to go to Elroy Wise, if you're ready to speak.
Can I tell them? I just came from the dentist, right? Literally, and my mouth is hurting, so I can't really talk. I don't know if you understand me or not.
We can understand you if you're comfortable enough to go ahead and address. I'm sorry that you're just coming back. That's very difficult, but we can understand you. If you do want to speak, you want to speak forward.
No, I don't. I don't. Yeah, I'm not comfortable because my mouth hurt. Like I literally just left and get my tooth pulled.
Okay, and if you haven't submitted something in writing, you can certainly do so, and that will be considered by the commission.
Okay.
And I hope you feel better. Thank you.
Thank you.
All right, we're going to go to SCI Cole Township, and the first individual to speak is Orlando Cruz. Make sure you're unmuted and you can go ahead and.
Sorry, they had just dropped off and just rejoined, so give me just a second to promote them again. And they were having some trouble hearing us. So.
All right, well, let's see when they reload if they're able to get a better connection.
Let's see. Cole Township, can you unmute? Are you able to hear us now?
Yes. We can hear you.
Okay, there you go.
All right, so very good. So I'm Judge Bernstein. I'm the chair, and we are turning over to SCI Cole Township for any public comments. The first individual I have listed to testify is Orlando Cruz. So whenever you're ready, you are welcome to go ahead and address. Thank you.
Yeah, we didn't hear nothing that was said prior to this.
Excuse me. One of the
Can you hear me?
individuals who spoke talked about what was being done to be addressed when there's one proceeding before the courts, but for multiple complaints in terms of sentencing on one and then using that immediately as an enhancement on the balance. We talked about the fact that that does still exist in that some of the changes, because there are no mandatories, it does not happen with a mandatory anymore. And also, I believe one of the things the executive director talked about in terms of what we're doing in calculating prior record scores and then in determining them, that the shift is to the current offense before the court as opposed to the prior record. So whereas the old sentencing guidelines, depending on the prior record, could end up at some points have a 9-fold increase, we've come to a point where the recommended 8th edition at its greatest variance would be double what it would have been, 2 times what it would have been with a 0 prior record score for the most serious prior record score. And we did that based upon data and looking across the board of trying to get some cohesiveness in the sentencing. So that's where we're at. I probably actually shared more than we talked about, but just to give you a little bit of an explanation. And then the other individual who was to speak, unfortunately, just had a dental procedure. So he is still present, and I indicated that if there was anything additional he wanted to submit, he could do so by writing. So with that, I hope that brought you up to speed and you're able to hear okay. And then Mr. Cruz, you may address when you're ready. Thank you.
Yeah, so pretty much right now, all you're dealing with is like parole violators. Is there anything new as far as long-term offenders?
Executive Director.
Yeah, if you'd like, we have there are 3 proposals. So the first is the sentencing guidelines. So that would not apply unless it was dealing with individuals convicted on or after January 1st of next year of any offense. Then those new guidelines would apply to that situation. The second is for resentencing guidelines. So if someone is placed on probation and the probation is revoked, guidelines for resentencing that individual. And then the third circumstance is, and this would certainly address those with long sentences, but not for life without parole sentences. And that would be for recommitment following revocation of parole. So if someone is released from the DOC on state parole and is revoked, has a violation, is revoked on that, these guidelines address how much back time the parole board would consider in applying for that violation of parole. So those are the 3 proposals we have before the public. So I think the third one probably applies most directly to those presently at the DOC, because if you're eligible for parole, a recommitment for a violation of parole is one of the proposals we have.
So there's nothing new as far as, like I said, somebody that hasn't made parole, that's doing a long sentence. Everything is after the fact.
Well, under the first one, the sentencing guidelines, we have new recommendations, or we're proposing recommendations for the sentences for courts to consider. So if someone was convicted of a serious offense, the guidelines have a recommendation of the sentence for the court to impose for that offense. And as the judge just said, one of the changes is to try to sort of restructure or redo the prior record score, because in the past, the prior record score substantially increased the sentence recommendation. And now, except for repeat violent offending, or multiple violent offending, the prior record score is pretty much capped at 2 times the recommendation when someone has no prior record score. So we're only, in the past, we would greatly increase the recommendation. Now, the most it does is double it if the person doesn't have multiple prior violent offenses.
And if I can but in terms of those who are already incarcerated, there's nothing in the new recommendations
Right.
that are impacting or changing anything.
All right. That's what I was asking.
Good morning, Ralph McGill.
Good morning, Mr. McGill.
I am a technical parole violator, and I've been incarcerated since 11/30/2021 for changing address to recommit to the state correctional institution to serve 12 months for violation, condition 7, I think it is, to see the parole board review. Well, once I seen the parole board, I have received my green sheet stating the max out due to I'm a risk to community and a bad recommendation from district attorney. Now, this what I don't understand. I accept my responsibility, but this what I don't understand. How can a person be a risk to the community when he was just out there working, getting his tax return and everything else? I don't understand why they don't have programs for guys like me and other persons that come in here to work their way back into society instead of maxing them out and giving them guys nothing to go on instead of them being mad at the world. And that will make them, no disrespect, a risk to society. They should give them some vocational training or something so they can work their way back into society. I'm 62 years old. I'm quite sure I'm not going to be no risk to society because I'm getting old and I'm getting tired. They need some programs. I'm on a parole violator block and I see them coming constantly and go out, come in, but they don't have none. They max them out. They don't have no vocational programs out there.
Executive Director, did you want to speak to that before I say anything?
Sure. I don't know the details of your case, but let me talk a little bit about what the commission is recommending for technical parole violators. So and this is consistent with legislation too, but if someone has been released from the DOC and the only reason for a recommitment is a technical parole violation, then the commission has recommendations about how much back time the board should consider, and also the type of facility where the back time will be served. So for a technical parole violator, if you're considered a non-violent offender, so the reason that you were initially committed to the DOC or your background doesn't have any violence, then the recommitment time that's recommended could be to a community correction center, community corrections facility, parole violator center. So that could be a possibility. Or if it's for certain types of offenses, it could be a recommitment to a correctional facility of up to 6 months. So I think you mentioned your recommitment was for 12 months. So I think this recommendation would be for a shorter period of time. And that's only if the decision was made to recommit. If there was a revocation or a violation of state parole and the decision was not to recommit you, then you would continue in the community under supervision. These guidelines apply only if the board has decided to recommit you. And then it talks about the type of facility you'd go back to and the duration of time. And at least for a first time violation of a technical violation, you'd fall into that category. If your previous offense or your background included violent offenses, the recommendation is a bit higher, but generally speaking, for that first time technical violation, it wouldn't be any more than 6 months. So I think that's a little bit different than what your experience is right now.
And then I just wanted to comment briefly, you talked about, programs working into society, and the hearing we're having today are the 3 areas where we're about to implement, but we're getting public comment to make any changes as we hear are being asked for. I think everybody's aware of needs for programming. It's not lost on us, but it's not something that we are currently tasked with or working on. But I just wanted you to know that you're heard, and that there are many people who would agree with that sentiment. Okay, so thank you. Anything else in terms of your comments? I didn't say this. I'm sorry, go ahead, Mr. Cruz. Was there anything? Or Mr. McGill?
No, I said I'm all right.
Okay.
I'm good.
I should have said this at the beginning, but I want to thank everybody for who's here today speaking. I mean, it takes a lot of, honestly, courage to step up and address everybody. And just to remind everybody, we do this literally because when there is input and we do have the ability to act upon that, your words are very much heard. So thank you. And then I'm going to move on to SCI Fayette. So if you're SCI Fayette, I can see you. If you can unmute, and then we're going to begin with Dorian Lamore, if they're present. So go ahead and unmute, and I will mute. So I still have SCI Fayette muted. I'm waiting for the little red microphone to go. No, I still have you muted. So SCI Fayette, is there anybody in the room who can help you out?
There we
There
go.
we go.
They got you now. You are unmuted. So we're going to begin with Dorian Lamore.
Okay, I got a prepared statement, so I'll just read from that and address any questions or make additional comments when I get done. That's all right? Okay, so.
That works.
Okay. Good morning. My name is Dorian Lamore. I'm a juvenile lifer currently incarcerated at SCI Fayette. Let me begin by saying thank you for the opportunity to give my input on the proposed sentencing guidelines for 2024. I am encouraged by some of the restorative justice sentencing alternatives, but I am discouraged by some recommendations. For example, violations of the Controlled Substance, Drug, Device, and Cosmetic Act, which reads, if any mixture or compound contains any detectable amount of a controlled substance, the entire amount of the mixture or compound should be deemed to be composed of the controlled substance. This becomes an automatic enhancement because the purity of the actual amount of the controlled substance becomes irrelevant. The penalty becomes greater than it would be because the amount of the mixture moves the OGS to the higher assignment. I think that the proportionality of the penalty and the offense are in opposition if the actual controlled substance isn't the barometer used for the OGS scale. The statute may call for the all-inclusive method discussed in that subsection, but the commission could recommend an alternative method, such as using the actual amount of controlled substance as the means to determine the OGS, especially since most people convicted for violations of the Controlled Substance Act will be eligible for alternative sentencing options. I would like to have a more in-depth conversation about sentencing and reentry. I believe that along with the penological dynamic, that there should be some restorative aspect to sentencing. The Quakers, some of the founders of this great commonwealth, believed in punishment, atonement, and redemption. They designed the concepts of this system with the creation of the first penitentiary. The goal was to punish the person, allow the person to seek penitence and redemption, which would allow them to return to society better people. We all know that lofty ideas don't always come to fruition the way that we envision, but it doesn't change the objective. As I read the proposed sentencing guidelines, I recognize that the commission is constrained by statute, and in most cases, the statute is draconian or too rigid. These statutes take away the discretion of judges in sentencing those convicted of a crime. For example, 9715 is a sentencing statute not addressed in these guidelines. 9715 is a recidivist statute that deals with multiple convictions for third-degree murder or manslaughter. The provision reads, provisions of this section shall not be an element of the crime, and notice thereof to defendants shall not be required prior to conviction, but notice of the Commonwealth's intention to proceed under this section shall be provided after conviction and before sentencing. Once this provision is triggered, it takes away the judge's discretion to determine the appropriate sentence because life without parole is the only option. I understand and recognize the punitive nature of the system, but restoration should be a component of sentencing. Every personal circumstances aren't the same. There are differences in crimes as there are in life experience. Situations aren't always black and white. There may be mitigating factors or aggravating factors. Judges should be given more discretionary options, a bigger range. Look at the sentencing range for juvenile offenders convicted of murder in the first or second degree. The floor is 420 to 360 months respectively for an offender 15 to 17 years old. The statute doesn't allow for a downward departure, but allows for an increase, and it fails to take into account the lifetime of parole supervision once the offender is released. There are approximately 300 juvenile lifers who have been released since 2016. The rate of return for those citizens is roughly 1%. The average amount of time served by this class of offender is roughly 26 years. It appears that 30 or 40, 35 years for the floor of those sentences is far more punitive than restorative because the statistics show that those offenders didn't need an extra 4 to 8 years to become productive citizens. This success rate is undeniable and even more impressive given the lack of resources allotted to those offenders for rehabilitation. I believe that a long-term offender who shows growth, development, contrition, remorse, and understanding of the responsibility that it takes to return to society should be given an opportunity. As I read those guidelines, I thought about thousands of people serving life without parole sentences in PA. I realized these guidelines aren't to address those. I just wanted to make a statement about those people as I'm here with my opportunity. A large portion of those people didn't kill or intend to kill anyone. The rigid nature of the statute didn't allow the judge to exercise his or her discretion to give an alternative sentence. In Maryland, they have a statute that allows for anyone serving a long numerical sentence or life without parole to petition the court to show that they've done what they've done, how they've grown and been rehabilitated. If they plead and prove that they are deserving of a second chance, then their sentence may be reduced. The judge has the discretion to impose a sentence that he deems more appropriate. Another state I looked at is New York, because they also have an undetermined sentencing scheme similar to Pennsylvania's. The difference is they have two minimum release dates. They have a certified release date and a minimum release date controlling, and a max date. For example, if a person is sentenced to 25 to 50 years, it is possible for you to be released in 15 years, which is your controlling release date, if you meet the criteria. Those who don't meet the criteria set forth must wait until their controlling minimum date being considered for release. The onus is on the individual to do the right thing. These are a couple options that I have for sentencing alternatives for more so-called high-risk individuals. In closing, I want to leave you with a quote from Nelson Mandela. He said that, "May your choices reflect your hopes, not your fears." And I'm ready for any comments or statements you might have. Not too much?
Mike, go ahead. Sorry, I was working on getting unmuted. Thank you. I read your written testimony in advance, and it's very thoughtful. Executive Director, I'll turn him over for the nitty-gritty stuff. So
Sure. Thank you, Mr. Lamore. That was really helpful and thoughtful. As you noted, some of these things are beyond the reach of the Sentencing Commission. They're statutory provisions. But the one thing that you did mention that is in the guidelines addresses murder 1 and murder 2 penalties or recommendations for those under 18 years of age. And one of the reasons why the number of months is set where it is because there are mandatory minimum provisions that require, at least that much time being served or ordered by the court. So the commission doesn't have the ability to mitigate below the mandatory minimum. So when you look at the 0 prior record score column, that actually reflects the mandatory minimum sentences. So the commission can't go below that. But I appreciate your comment. It's a helpful comment in terms of just thinking about the duration of those kind of sentences in the guidelines. Thank you, Judge.
thank you. All right, and then I also have Antonio Lindsay with SCI Fayette. If you're ready to address, you're free to do so now.
Yeah, hi. Thanks for having me today. My name is Antonio Lindsay at SCI Fayette. And I came here in 2021 as a parole violator. upon which I was serving a 6-month parole hit. While here, I was then I received another charge of possession of marijuana while incarcerated. The marijuana was in my vehicle at home. My parole agent went into my vehicle at home at my house and found the marijuana, which I have a medical marijuana card for. Because the medical marijuana was not in its original container, I was sent back. My parole was then revoked, and I was made to see the parole board again, at which time I was given a year hit by the parole board, which I think personally was excessive for the marijuana, being as though I was a recipient and I did have a card and my parole agent was aware of it. What I want to address is, in the state of Pennsylvania, 64.7% of parolees return to prison within the first 3 years of their release from prison, while the national rate as a whole is 67%. That's more than 2 out of 3 parolees. And my I can only come up with or come to the conclusion that because we're not able to obtain, as the young man from Cole Township said previously, adequate training to pursue other means of, as far as trying to stay out of prison, things of that nature. Myself, I recently went back to college while on the street. I went to Westmoreland County Community College to finish my degree in child care behavior. And again, I was violated for this medical marijuana and given a year for possession of this marijuana. And I think that, again, was excessive for just that. And it was, come to find out, it was based on my previous conviction, which was from 1988. I served 22 years of a 22 to 58 year sentence. I was paroled, at which time upon my parole release, I was not deemed a threat or a risk to society, as the young man from Cole then indicated. And now, because of my marijuana conviction, I was denied parole for being a risk to society somehow. I'm not sure how that is comparison to my now being incarcerated for marijuana possession. And I personally feel that parole agents do not have, the parole agents do not have the resources that are needed to assist the parolee in the area of obtaining things such as housing, jobs, or lesser needs for the success of a parolee while on parole. But the threat of coming back to prison remains imminent for things like unpaid fines, which is imposed by the courts at times. And we're not able to pay those fines because of work, our history, our criminal history that is held against us. So when you go to obtain a job and, you're denied a job because of your felonies and things of that nature. So then we're not able to pay a fine when a warrant is then issued. And again, you're violated and put back in prison. So I'm trying to find out why is it that, no one has looked into these, the possibilities of trying to have the parole agents work with us to get us employment, as opposed to putting us back in prison for unpaid fines and things of that nature, as well as, I'm sorry, I'm a little nervous here. This guy made me, he was so prepared and, I'm just jumping around.
You're doing well, so no worries.
Yes, so and on allegations, an individual while on parole, if an allegation is made against you by someone on the street, we are immediately arrested by the parole agent and brought back to prison to sit here for 3 months, 4 months, until we're able to prove our innocence. While in that time, we lose our jobs, we lose our housing and things of that nature, as opposed to being put in a halfway house where we can fight the allegation charges from a halfway house of some sort, or some under ankle monitor at home, or things of that nature. And those are the things that I wanted to address today with the commission.
Thank you very much. You covered a lot of issues, and they're all very thoughtful for certain. Executive Director, did you want to address anything as they may tie to the 3 areas that we're currently doing?
Yeah, I don't have much to offer. Let me just mention a couple of things. One is that I understand what you're saying about the resources that parole agents and others need and how that would benefit individuals released from the DOC. And there's been a lot of effort in recent years to sort of restructure how we do parole and how we provide community supervision and support. With many of those services now under the Department of Corrections rather than sort of separately under the parole board. So I think some of these changes have been made to improve coordination, but also to really try to promote what you're talking about, providing support and assistance. And I know there's a lot of efforts, and there had been with the board, and there are with the department. But by you testifying, I'm glad you're raising the issue that more needs to be done. So I appreciate your testimony, and I know that individuals from the board and the department are watching this or will have the opportunity to watch the recording. And I hope those that appropriate funding will also hear it, because I think you're right. That's an important consideration. The other thing that we can discuss with the board and with the department is I think something separate from our guidelines, but an important factor, and that is I think what you were talking about was when someone is effectively arrested for a new charge or detained because of an allegation of a violation. They're detained and they go back often to the facility they came from, and that's a little bit different. That whole detainer process is a little bit different than what we're dealing with. Is what happens once there is a finding of a revocation and there's back time that's ordered. So I think you're dealing with a disruption that I understand the point. If you're out in the community, going to school or working or, things seem to be going well, and you're detained because of an allegation, that disrupts the whole thing and takes you away from your job and could compromise your housing, could, compromise the school and all that. So I hear what you're saying. And again, I know that the board and the DOC, are trying to make sure that people are successful when they're out there and not putting roadblocks in the way. But I'm hoping that, if this is something that can be addressed, keeping public safety in mind, but if there's a way to use community correction centers instead of correctional facilities so that you can maintain that, I think that's something they try to do, but each case is different. But I just wanted you to know that I appreciate what you said, and hopefully through these hearings, other people will see it and see if there's any kind of gaps that can be filled. So thank you for your testimony.
Thank you.
Thanks to both of you. And now I'm going to go to SDI Muncie. We have 2 individuals to speak from there. So we'll begin with Fatima Smith. If you good morning to both of you. And if you're already unmuted, so you beat me to the punch. So you can go ahead and address your comments. Thank you.
First and foremost, good morning and blessings to all that's present. My name is Fatima Smith. I am residing at SCI Muncie right now as a TPV. I chose to commit a crime in 2010, which resulted in receiving an 8 to 20 year sentence. And pardon me, by the way, I have a little cold, so. I made a choice while residing at SCI Muncie to not just do my time, but to utilize whatever resources I could. I graduated not once, but twice during my incarceration. I attended many groups and worked as hard as any man could on 2 different carpentry crews. I vowed to God and myself to never hurt a human being again. I got paroled my first time in 2018. I'm back at SCI Muncie for a second time as a TPV for absconding. I have not let my God, family, or myself down by hurting someone or even committing another crime. Yes, I chose to leave a drug-infested halfway house and refuse to enter another one. The justice system / parole board says that these places are to be safe and drug-free, while you have to fear the staff as well as your peers. I have maintained a job since my release in 2018. I drive for Amazon, have my LLC, which I use to sell stuff on Amazon sellers. I own my car, I pay taxes. I have the proper paperwork for everything listed above. I was sentenced to 9 months for absconding with no credit. Yet other peers get 3 to 6 months of repeated drug abuse, DUIs, and new charges. Being the only one in my TPV program who did not or have ever done drugs. Yet I still have to stay the same amount of time as the ones who did. Even though I chose not to be a statistic, I'm still judged as a whole. I believe once parole, facts and proof should be evaluated just like they are for original sentencing, and not this point/quota system that is in place now. It should be monitored in some type of way so there's no room for any kind of prejudice. The question that I have for the statement that I just read is, even though I committed a violent crime over a decade ago, I know that has to go within the guidelines, but also why are the good things that individuals do are not credited towards my time? It's just confusing. Like, I know you have to go by a guideline, but also if somebody committed a crime that's, over a decade old and, they strive to do certain programs, it's like I heard a couple of the gentlemen saying that, it's no options out there, there's no vocational training, this and that. So if I went above and beyond, graduated here for carpentry, did everything I'm supposed to do, went home, and made a career out of that and still succeeded to this day, why is no good credit given, only bad?
Yeah.
Go ahead.
Yeah, let me try to address part of that. And I don't have the details of your case, but let me just talk generally and what we're trying to do with the recommitment ranges. So one of the things you raised was sort of the difference in the recommitment ranges between someone who has a violent past, so we, sort of labeled as a violent offender versus nonviolent. And what we tried to do there is, if you look at the recommendations, the sort of the maximum period we're recommending is the same for both. It's just for someone with a nonviolent past, we include greater discretion to go down much lower, to give much less back time or none at all. So the recommended back time, sort of the cap that we recommend for back time, is the same regardless of your background. It's just the board has more discretion if the background is nonviolent. And part of the reason for that is, under the legislation we're required to consider, we have to have different guidelines in place for violent versus nonviolent offenders. And the definition we're using is the definition used by the board and the department in defining past behavior. Now, I'll have to look if there's a look back period, if after a certain period of time that doesn't apply. But that's where, for technical violations, that's where there is the cap is the same for both. Now, when we move to convicted violations, when there's a new conviction offense, you'll see that for less serious offenses, the guidelines are effectively the same for violent versus nonviolent past. But when you get to more serious and violent new offenses, then there is a difference, because there is a concern if there was a past violent behavior and now there's a new violent behavior that should warrant some more substantial back time. So that's why those are structured that way. When we get to the issue you raised about whether you received credit for street time and things like that, our guidelines don't address that, but it is a really important issue for that. I know the board considers, and they try to take things into account. When we started this hearing, I mentioned that these are new. These are initial recommitment ranges. These aren't in place right now. We're creating something new. But as you probably know, the parole board had internal policies that they use to sort of guide recommitment time. And what we've done over the last number of years is try to work with the board to come up with recommitment ranges that sort of reflected what they did, but also tried to structure it, because it was not particularly clear at times how much back time you'd get, or there was a really broad range, or it was unclear how this offense was dealt with. So the board's been great in us working together to try to understand what they're doing, and then try to come up with a plan that we thought was sort of consistent, that we could put out for public hearings. So your feedback right now is helpful in determining whether, we improved the system or if we have more work to do. But this is the third proposal that we published, because we've been adjusting it based on what we hear from testimony. So I hope some of that addressed it. Again, without details of your case, it's hard to exactly know how this applies. And part of that is a discussion between you and the board. But I hope this made some sense in terms of what we're proposing.
I thank you for, I'm sorry.
No, go ahead.
I thank you for that. Also, we received the packet with some of the guidelines that you were stating. Is there any way that a guideline can be in place to where as though that individual person has to get evaluated, not as a whole, but as an individual person? Because sitting in the TPV program that I'm in now, and just like the previous gentleman stated, he has a medical marijuana card, so do I. I never got reprimanded for having that medical marijuana card. And while I was prescribed that medical marijuana card was in 2018, a week after I came home, my brother got killed. 6 months after that, I lost my grandma. So during, this time, trying to adjust into the real world after losing almost a decade of my life for doing my time, even though I chose to commit that crime, it's very hard to adjust into society. So if I broke those barriers, why isn't a guideline put into place to look at that individual? Because if I was to go and hurt somebody, then the parole board would have been like, see, I told you, this person shouldn't have got parole, she committed this violent crime. I have not been violent since over a decade. And sitting in a TPB program where people, are ODing off of fentanyl, or being placed into a halfway house where I have to step over, drug needles, where, the parole board states that I'm supposed to be safe. It's, I have PTSD, it's very, very stressful. And, if I didn't have the faith in God, I would probably give up. But I do have a strong faith in God, and I do believe you guys are trying to make a change. But is there any way that something can be done, in these guidelines where a person is judged as an individual and not as a whole? We have to do better. We have to do different. It hurts, like I said, seeing peers get released who have, heroin addictions, crack addictions, and I see the parole board, feeling sympathetic for them. But because I committed a violent crime in 2010, I get no credit for the hard work that I've done, and not just at home, but in jail too, to get paroled my first time. So, once again, I do thank you. But, I think, as a whole, everybody should kind of do better for guidelines to look at the individual person, not as a whole. But thank you.
Thank you for that. And if I could just add one other comment, and this applies to all of these guidelines. So whether it's sentencing guidelines that judges consider or recommitment ranges that the parole board considers, these are all advisory guidelines. So they're intended to sort of put a roadmap there for judges or parole board members as a starting point to say, in the typical case, here's what we're recommending. And here are a handful of factors that you can consider because they're sort of objective factors. So that's what we're putting in place. We're putting in place recommendations that are advisory, that are based on a handful of factors that we know are available and that we can sort of compare apples to apples among people coming through the system. But you pointed out an important part of this, one thing that the guidelines don't do, and that is that any decision maker, a judge, a parole board member, a hearing examiner, a parole agent, they all have discretion. And they have to use that discretion to look at individual factors and try to weigh those factors and determine whether what you're presenting is typical or not. Does it sort of fit what we're recommending, or is it different? And it might be different, like worse or better, but is it different? And that's why those individuals are in their positions. They have the authority to exercise discretion and take into account those factors. So, if you're articulating reasons for, let's say, mitigation for, that thing shouldn't count as much, or these positive things should count, that's important. And that's why they're advisory guidelines, because those decision makers do and need to take into account those factors. But we need to give them a starting point based on common objective factors. What was the conviction offense? What was the background? Things like that we can compare people, because just like you want those individuals to have discretion, we also want to have some uniformity in place, some standards in place so that people are treated alike, that we identify factors that sort of say, it's only fair if you get the same thing based on these same factors. So that's why we're using those for starting points. But these decision makers also have to look at the other things you mentioned. So whether it's a judge or a parole board member or a parole agent, they all have to exercise that discretion. And part of that is you communicating to them, those positive things. And they have to also look if there's negative things too.
Okay. Thank you.
Thank you.
Thank you. I have, if I say it correctly, Charlotta Abbott.
Charlotta.
Okay, so Ms. Abbott, you can go ahead whenever you're ready.
Okay, good morning, first of all, and some very interesting topics I want to touch on. My name is Charlotta Abbott. I am 55 years old and currently a CPV at SCI Muncie. I was paroled 2016 from Muncie, maintained a good job, and also was in college for social services. I was an assistant manager at a large clothing company for 4 years, doing good on parole and managing life, but then COVID-19 came. I lost my job and was financially unstable. I couldn't pay my bills. I couldn't even pay parole or child support that I was liable for. I was in a bad way. I ended up committing a theft that left me feeling so regretful afterwards that instead of continuing down that road again, I chose to execute a better plan and interview for a job as a truck driver at Amazon. And I got the job. I maintained the job for 6 months, but because of the pandemic and the rioting, the job became dangerous for a woman of my age. So I decided to move to North Carolina with my family and my husband. It proved to be the best decision I ever made in my life. I was able to establish housing and create a cleaning business that I love so much. Despite the success I was having, I still had the answer for the theft. On April the 21st, 2020, I was arrested and brought back to PA, where I sat in the county for a year and was given a sentence of 1 to 2 years. The judge took in consideration that my crime was out of desperation during the pandemic and for the remorse I showed and the fact that I paid every penny back. Those factors did not excuse my action or behavior, but it did show that I was pro-social and that I cultivated change. I had my life on the right track until the pandemic. I had not been in trouble since 2012. After being sentenced and returned to Muncie, I received a 12-month hit and 2 years of my street time taken and added to my max, which changed my max from 2024 to 2026. Once I finished the 12-month hit, I seen parole again. And I thought after the programming that I was requested to do, plus I did more, that, you know, I was going to be released. That was not happening. My green sheet say max. I was devastated. That meant I would do 5.5 years, all because of my record. I understand that the sentencing guidelines are put in place for a reason, but when do we go out of the guidelines and make our own rules? I understand the decisions to recommit is granted, but how can we as inmates ask the parole board to have leniency on offenders? I'm a nonviolent offender who will agree to the proposals that are being proposed now. Courts and parole boards should consider to change the guidelines and also put in place a way where the OGS, the offense gravity score, will change for the offender time at liberty, lowering the score so it won't be held against one's record. Because when we are in front of the parole board, all they see is your past. That holds more weight than anything. The procedures for determining resentencing guidelines are needed for technical and convicted violators, especially using the PRS, the prior record score, with mitigating and aggravating circumstances. Because of the decisions that are handed down are more reflected on paper, your record, than based off factors such as accomplishments, productiveness, and the length of time between arrests, we as offenders would really appreciate the change in these guidelines. It's like rebooting the system and trusting that someone is listening and will allow these changes to happen. That you will see past the black ink on paper and acknowledge that one size does not fit all. Also, to implement incentives where doing the right thing really does have its rewards besides living life. I trust that these proposals for the state parole guidelines will be passed and implemented to change the current ones. In conclusion, I thank you for your time, and please do not let us go unheard. I have 2 comments. I listened to some of the young men on here, the one guy, he got a hit. He did 12 months. He was a technical violator. And then he got his paper back and it said max. I received that same entity. And I thought that because I hadn't been in trouble so long and I had so much going on, that when I was returned here, that they would be like, okay, she's gonna do this year hit and then we're gonna let her go. When they told me the max, I felt like, where's the hope at? That would leave me in a range where if I didn't have conviction and have God in my life, I would go back out and commit more crimes. But because I got a family that loves me and I know how to stay on the right track, because when I fell down, I got right back up and I did something different. Does that count for anything? Can that change the prior record scores of saying that this person hasn't been in jail this amount of time, so can we do something different with her? Instead, they gave me a sentence more than the judge did. The judge gave me a 1 and 2, which I'm currently finished, but the parole board gave me a whole nother sentence judging by my record. But I'm 55 years old, and as the other young man said, what more trouble could I get in? I moved all the way down to the country where I thought was the best change I ever made in my life. And I want to know, are we listening to us or are we just pushing paper?
Thank you so very much for your comments. And I can say on our end, your comments are certainly heard. The commission spends a lot of time after public hearings discussing and seeing where the comments could fit in and where we have the capacity to effectuate. And again, please understand we are mandated by the legislature, so our role is limited to some degree, but certainly we have input in a lot of these areas. And then I'll turn you over to the executive director if he's good at the specifics.
Sure, and thank you, Judge, and thank you, Ms. Abbott. One thing that that I mentioned before was about the exercise of discretion. And the other thing I mentioned was that the commission's worked for a number of years in building these with the parole board. And I can tell you that I know it's sometimes, difficult to see when you're looking at specific circumstances, but I know the board is committed always to try to do the right thing and trying to, when warranted, not use recommitment, trying to keep someone in the community. And when things get to a point where they feel a recommitment is necessary, then what we're trying to do with them is come up with sort of standards in place as that starting point. But let me mention or just read a section that we inserted into these to make sure that there's consideration of some of the things you mentioned. So in addition to providing these guidelines, we say that the board should consider any aggravating or mitigating circumstances, including progress on parole prior to revocation and the rehabilitative needs of the offender when determining the duration of recommitment and prescribed treatment and programming. So, and I know the board is committed to that. It gets to resources, it gets to a lot of other things, but I think, if someone is, makes a mistake while on parole, there's an accountability factor, and you even recognize that in talking about your circumstance. And I think in this case, you're saying was the response proportional? Was it like too much given what you did and the sentence you received and other things like that? And those are going to be they're going to be judgments made, exercise of discretion. But I hope that if nothing else, in these guidelines, these recommitment ranges, you can point to this and say, here's my case for why, either you should mitigate or that you should, take into consideration these kind of things. The guidelines talk about looking at these individual factors. So again, I think I appreciate your positive comments about, this hopefully being a step forward, putting this in writing, trying to have standards in place, and to address not only your comments, but other comments made. Part of the process of the commission putting out these guidelines, putting them in place, is that then we build in place a system with the parole board where they will report to us all of their decisions. And then we will be publishing what we call conformity. Is the board going with our recommendations, or are they going outside of the recommendations? And what are the reasons why they're going outside of the recommendations? So it gives all of us, the public, sort of an insight into what's happening. Is this working the way it's planned? Are there a lot of times when they're going high or low, and why is that? And we get to continue to review it. So the commission, the 11 members of the commission, get to work on this all the time, of reviewing what they hear and see and seeing if they have to change or adjust things. So these are the initial recommitment ranges, but there will be an ongoing opportunity to adjust them based on what we get as feedback from the decisions being made. So thank you again for your testimony. It's really helpful.
And also, I want to thank you as well. I guess, was there anything else from Ms. Abbott before I wrap us up?
Yes, I would like to ask a question. I heard everything that he said, and I appreciate it because I did read the proposal and it hits right on. But I also would like to know, when does it come a time where parole can't be biased? Instead of putting what they see in front of them, it would be like our warden is here and our deputy warden is here, and if they pass a vote sheet around and they say, we recommend this person to be paroled, this person has did A, B, C, and D, and then when parole see you, they like, no, and they hit their number buttons, because I think it's a number button from 1 to 12 where they say risk management, lack of want to participate, anything. But how would you know that if you're not here with us, and these young people that's here with us, administration, will know us better than you do? So I would like to know, where do it comes a time where, are they really going to check in with you, or are they still going to be biased and make their own decision?
Yeah, there's it's a good point. You know, we have to sort of trust people working in the system to be doing the right thing. And we're doing what we're trying to do with setting this up and setting up this reporting system with the board is to try to document what's happening and linking that to decisions being made, and then testing that to see if it makes sense. What I think you're talking about is, you know, what if the agent, you know, sees things differently than you see them? How do you like resolve that? How do you make sure there's truthfulness in the process, or that the full story is being considered, that there's not bias in decision making? And look, I think, you know, between the board and the department, you know, they have a responsibility for like managing and overseeing the work of their staff, and that's an important thing. And I know they try to do the best they can, but you know, there's you know, what we try to do is have things in writing so that you can document things and you can test them. And if someone said something but it runs counter to what you've said, that someone independent of the two of you get to look at that and make a decision, that it's not all one or all the other. It's someone trying to, you know, determine what happened or how serious it is or how much weight to give something. So this is an ongoing process. I think you raising the concern about it is helpful for the department and the board to, you know, think about how they can improve their operating procedures to make sure that those concerns, I mean, we want people to feel it's a just and fair system. So you raising it, saying, hey, we have concerns about it, I think is a heads up to them to be looking at things they can do to continue to improve the system. So I'm glad you raised it.
And one of the things that we've talked about, and I'm synopsizing this, but there are concerns raised sort of how many times and how many ways can somebody's prior record be used. And we were aware of the fact that a lot of times things were doubling up. And I think some of the things that we have done have improved upon that. And an example of something that I'm going to give is because there are ranges of recommitment and they are discretionary. But as a judge, sometimes I have somebody and I know they're sitting on a violation and I'm sentencing them on this new offense. And I have an idea of what I'd like to see happen. But what I don't want to do is on either side error. I don't want to say, oh, I think you're going to get a hit for this amount of time. Really, I think overall, this is how long you should be sitting. So I'm going to come down on my range some because overall, I think that meets the purpose of what I'm looking at. And the same can be the opposite, but we're left at pure guesswork. So although the recommitment guidelines are discretionary, it at least gives a judge some ability to say, this is kind of what they're looking at. And it helps because if I have somebody in front of me, certainly who has, I understand the prior record as a component, but I also understand, and maybe part of that is time and experience, is that is but one measure. And where are you at? Are you employed? Are you connected with your family? Do you have social support? Do you have a place to live? Those are all things that I think more and more judges are aware of as considerations. So if I'm looking at all of that, I still know I don't have the control of what's going to happen in parole. But for me as a judge, it is beneficial to say, hey, at least I know this is the guidelines of what they're looking at, because it allows me to effectuate what I want to have happen for that individual, to put them in the best place to be held accountable, but also to not recidivate and to continue, and improve position for themselves. So that's just something that's a benefit as a result of what's happening. And also the last thing I want to say is for everybody, we take this back to the commission. We talk about and we look at where, is there something that we see that we want to change? Is there something that we want to measure that we weren't going to measure? Because we take data and that informs us. And when we have that data, we can make better decisions. So I know the executive director has something to say.
Just one final comment about our work with the department and with the board. I should have mentioned earlier that the Secretary of Corrections and the chair of the parole board are what we call ex officio members of the commission. So they're part of the commission. So when the judge talks about the commission reviewing and discussing testimony received and thinking about the guidelines, the various guidelines, the secretary and the chairman are also part of that process. So it's yet another way for them to hear what you said. So again, I appreciate you taking the time and putting all the effort into your comments today.
Yeah, thank you very much. And know that there are commissions and agencies and advocacy groups who weigh in, and a lot. I feel like people are being heard, and so including all of you. So I thank you all for your time. I know Representative Bonner came on and we didn't recognize him initially, but he is also another commission member. So thank you also for joining and being a part of this, Professor Rago, and to everybody who was here to share their thoughts. So I wish you all, is there anything else before we go? SCI Cole Township, you can unmute, and then I think that's Mr. McGill.
You'll have to unmute the Zoom as well. Sorry.
Hang tight. We're still working on the unmute. We're good.
Okay, Cole.
Good morning again.
Good morning.
Well, I want to thank the people at SCI Fayette, Muncie's, and the young man over here. But the young lady in there, she brought up some positive things that I understand where she's coming from. But what we asking for as a whole, we asking for help. We asking for help. Being incarcerated so many years is a mental thing. We deal with trials and adversity, with deaths and everything, but it's definitely a mental thing. We need help. We come back in here and we do the right thing for the parole board, but we're doing the right thing for ourselves because we're trying to stay out of here. We're trying to keep the chains off our hands, but we're definitely trying to keep the chains off our minds. We're trying to do the right thing for the right reason in life. Being incarcerated is a mental thing. I see this young man beside me every day doing positive things, staying involved in the community inside the institution. I lost my son of Housedale, 2013, was murdered. My little brother was the first homicide in Philadelphia, 2021. I'm the oldest. I thought they was gonna bury me, but I kept on fighting out there in the world. I kept working. I kept going to AA. But when I buried my cousin, 2021, I started drinking. I felt in depression. I felt that I was alone. So I changed my address and I non-report. I turned myself into the parole people. Serve a year, back time. Okay, I accept responsibility for that. Like the young man said, I lost my job, I lost my apartment, I lost everything. All I asked for was help. It's a mental thing. I grew up in these prisons. I'm trying hard to keep the chains off my mind. I do the right thing. They max me out. I accept responsibility. I didn't stop doing what I had to do in here. I'm still a facilitator in AA. I still work in the kitchen. I still go to GED classes. I still go to NA because I'm trying to change what's inside of me. I can stop all that and just max out and be mad at the world. I'm not mad at the world. I'm mad at myself. That's why I'm trying to change myself. It's a mental thing. All we asking for is help. Healing every live person. That's all I ask for. Thank you. Thank y'all. Thank you, Muncies and everybody.
And that was very, very powerful and sincere and and heard. So thank you.
Thank you.
And then I appreciate everybody's comments today. I'm going to turn it over to the executive director to close out.
I believe SCI Fayette has a comment.
I apologize. Yep.
Yeah.
Yes.
Yeah, real quick, Mr. Bertram, I'm sorry to interrupt or come back in. Something you said, you constantly, we sitting here, we talking about guidelines. Having guidelines and following guidelines are two different things. We constantly, what I didn't mention or what I failed to mention previously was, we talking about guidelines. My marijuana conviction that brought me back here, I filed for it to be removed from my record, and it was removed. The Board of Pardons told me that it no longer exists, although I'm still sitting here. I wrote the records department, and then I wrote the parole department, and I expounded on that, and I told them that it was removed from my record. And they say, yep, you're no longer in for the marijuana. You're now in for your old case, which was confusing to me because the marijuana was the initiator for me being here. So the Board of Pardons and Parole negated the marijuana conviction, which was only $100 fine, by the way. So the guidelines that you speak of, I don't want to, be long-winded or whatever, but because the marijuana conviction was removed, the parole board then told me, well, you're no longer dealing with the marijuana conviction. Yep, it was removed. You're now doing back time for ever even coming in contact with the new charge. How does that, where is the guidelines at for that? I mean, I was under the impression once the marijuana conviction was dismissed, I was no longer needed to, be here because that's what brought me here for my the new charge.
Yeah, and this is, this is difficult to respond to because I don't know all the details, but if there was, when you're talking about the Board of Pardons, did you receive a pardon on the marijuana, or was it a clean slate provision that it was wiped out?
I'm sorry. I received my counselor by the name of Miss Esteban. We were all, confused as to what this meant. So she called another individual who used to work in the records room who were more familiar with it. And she contacted somebody from the Board of Pardons, and they said that marijuana conviction no longer existed. So whatever that means, it means that it was. But then again, the parole board is saying, well, because of the initial contact with the, for having the marijuana in itself outside of the container or whatever, that's done. All of that's done. But you're here now for under your old conviction.
Right.
Because the marijuana led me to be back here.
Got it. Yeah. So let me just say this, on these details, I know we have individuals from the department and board involved in this hearing, or at least observing. And what we can do is try to look at the details of your case just to resolve this, or so that you have a clear understanding of all of this. I know there are circumstances where someone is charged with something and maybe, subsequently it's dismissed, or or there's a subsequent pardon or clean slate provision where the act itself might be a technical violation rather than a new conviction violation. I mean, there's a lot of things that could happen. So what we can do is, outside of this call, I'll see if we can just get a better understanding of your specific case, so that at least you know what that was all about, because you should know. They
explained to me what it was, Mr.
Okay.
Bergstrom. I'm sorry to interrupt, but I go up for parole in April anyway, so I don't even want to rehash it. I'm about to go see the parole. I don't want to piss anybody off.
No.
Fair enough.
Okay, I'll withdraw that offer.
Thank you.
But let me. I will mention something in response to what you said about, having guidelines versus following guidelines are two different things, which I totally agree with. They are two different things. And that's why, one of the things the commission does, and whether it's judges and sentencing guidelines or the board and parole guidelines or recommitment ranges, is to try to make sure that we put in place these guidelines, and then we have information on decisions made under those guidelines. So we would get information on your case about what the guidelines were and what decisions were made in your case. And then we remove the names, but we do analysis to try to figure out what's going on when you look at all cases, not just yours. And then we also publish this information. We make it available to the public, because it's sort of like a check and balance on the system to say, we put this stuff in place, but what if no one's following it? Well, we should make sure the General Assembly knows that. We should make sure the public knows that. And it could be that they're following it and it's wrong. We should do something different. So we try to use the information to hopefully improve practices. And we do that by making it public and also doing a lot of analysis on sort of what works. So I agree with you. It's, you can have the guidelines, but people might not be following it. And that's why we need to just make sure we make very public what we're seeing, so that there is a check on it. So thank you again.
Thanks, Mr. Bergstrom. Thanks, Mr. I'm sorry.
I got one question real quick.
And then I see SCI Muncie. We're saving the best for last. That's
for sure. So is there or could there be any repercussions for the parole board if they deviate from the commission's recommendations?
So I'm not sure what repercussions. The commission will be collecting
any recourse that can be taken.
Right. I think initially, because this is brand new, we're just doing this now. Initially, we're going to be looking at the process, do the guidelines make sense? And what we can do is we can do research on when people are released or people aren't released. And then, 10 years later, we're looking at outcomes. Does it matter? Were the guidelines, good or bad in terms of helping to protect the public, but also helping to move people through the system and recommend parole and things like that. So that's why we collect the information to try to see if the board or judges are sort of following the guidelines, and then also trying to see what works, what things seem to work best in terms of good outcomes for everyone. And that's what our goal is. So I think that's our primary focus. But eventually, and we do this with judges, all of our sentencing information is available and it has the judge name on it. So individuals can look at a given judge and say, do those sentences sort of fit what other judges in that county are doing, or other judges statewide? So there is over time the ability to then sort of think more critically about individual decisions, not just how the system works. And so with the parole board and our work with them, eventually maybe that will be part of it that you can start looking at board members' decisions. But initially, it's about just trying to make sure we got the proposals right, that it makes sense. Thank you.
Thank you.
All right, thank you. All right, I'm going to go back over to SCI Muncie. I think, is it Ms. Abbott who was going to address?
Yes, Mr. Bertram and Judge Bernstein, y'all sound like real stand-up people for us. And I hear everything you're saying, and some of the stuff I see in the making. But I have one question. I'm gonna give you an example. You go in front of the parole board, you go on a video screen just like this, and you sit down and you have a conversation from them. In front of them, they have your information. They have your information of what your warden, your deputy warden, your sister warden, everybody says about you. And they tell you, they ask you parable questions like, what are you gonna do when you leave here? Why should we let you go? And you already got a job because you're a parole violator. Most of us, some of us come back and have jobs already, have housing and everything. We already set up. And then they ask you all these questions and you tell them. Then you get the green sheet back and says 12 months. Then you get 24 months. Then you get maxed out. Now you done lost your home. Now you done lost your job. What do they expect us to do? I mean, we go home, we're gonna have to start all over again, especially us of age that are vintage. It's kind of hard to go home and get a job. That's why I took what I learned from here, cleaning, and I made my own business. And I started cleaning toilets for a living, people's houses. What would they do to expect if it was somebody younger than us? Like, what do they want? Because I seen the sheet that they answer the questions and how they make your score or what you should do, how you fit into mitigating, aggravating circumstances. Is that going to change also? Because you can't just look at me and never met me before and say, oh, your record say you're going to do this again. I don't care. Max out. When these people on the sidelines, they know us. And I feel like, I'm not going to throw y'all a new job, but I feel like the people that work here in administration should be allowed to sit in parole too, because they know us. Some of us grew up here. They know us and they know what we're not going to do and what we're going to do because they see us 24/7. And when they know you by first name, you was a problem child or you turned from a problem child to a good child. I just want to know, are we going to be able to help this young man in the corner who's back in there and he done lost everything? Are you going to be able to help this young lady who is striving and can't be at a halfway house because the halfway houses is not safe? They got more drugs than the street do. So what do? Like, we have a few of y'all, but not enough. Not enough people to say, these people really trying. Like, what do?
Yeah, so there's, and this gets to our parole guidelines, I think, maybe more importantly than the stuff before, that we have out for review right now. But we just put in place parole guidelines that started in January, and they're being used by the parole board now. Same kind of process we went through for recommitment ranges, but for the parole guidelines, what we tried to do was look at what the board had been doing over time. Like, what kind of factors did they take into account? When were they more likely to parole someone or deny parole? And then we looked at how did people do when they were released? And what kind of characteristics led to someone not being revoked versus someone doing well? And what we found, and look, the board was doing a lot of good things, and they have a lot of good members. So I don't want to throw them under the bus, but I will say that through working with them and like looking at data, we were able to try to figure out what were key factors around risk of reoffending and what were key factors around preparedness for parole. And if you look at the new parole guidelines, those are like the two fundamental things we're looking at. So for instance, under the guidelines now, under the parole guidelines, there's a bunch of factors when we're determining if someone's prepared for parole, that goes into the scoring of like a recommendation to parole or not. And some of those are exactly the things you talked about. It's like the recommendations from the Department of Corrections or a unit manager or someone like that, someone who was leading a program that you were involved in, to talk to people who were there, who are living with you and working with you, to provide their insights about whether you're prepared for parole. But there's also other stuff, like during the parole interview, there are factors that board members are interested in. Like, do you recognize, the problems in the past, and do you have like a game plan for avoiding those problems in the future? We don't want repeated offending. So they have a lot of things they look at. What we tried to do with the parole guidelines was document all of this, have the parole board use it. Again, it's advisory. It's just a starting point, but at least we get them to like score these factors and write comments if they decide not to parole when it recommends parole, or vice versa. But then that information is going to be available to you and to anyone, so that you don't just get a green sheet. You get your parole guidelines, and you get the reasons why you were either paroled and what the conditions would be, or the reasons you were denied and what you have to work on, which we think, the board was doing a lot of this, but we think it helps improve that process of knowing what was good or bad and why you were paroled or not paroled. And that same approach is what we're trying to use with these recommitment ranges, that you have a better understanding of like why you're here, why the setback, and what are the expectations for you to be re-paroled. So that's what we're doing with our part of the system. Lots of other people are way more involved and have a lot more discretion, but we all have to do our part, and that's what the commission's trying to do, to what we think is improve the system and just work with the board and the department and with you to make sure we all know what's going on.
Sir, I have one quick thing to say. To all my brothers that spoke today, I see you, I believe in you, I'm proud of you, and please don't give up.
Good words.
Thank you.
All right. Really great comments, and very well appreciated, and definitely things that we bring back to the commission as a whole. Is there anything else, Executive Director Bergstrom, that you wanted to add before we end today's meeting?
No, thank you. Just thank you to all the participants. Thanks for the other commission members and yourself, Judge, and to the public watching in the future the recording. Really appreciate all the effort that went into this. And thanks to commission staff, Christy, Ryan, Brett, Matt, everyone who helped bring this about. Kathy for all the Zoom links and so forth. So thank you.
Thank you. And for all the individuals who spoke today, we recognize that you are representing more than just yourselves, and that you're representing individuals that and issues that you've seen with others. So thank you for being the mouthpiece, not just for yourselves, but for others as well. And with that, then I think we'll go ahead and end today's meeting with our thanks from the commission.
Thank you, everybody.
Be well.
Thank you.
all.
Thank
Do
you.
well.